One of the most difficult things an estate planning lawyer can ever do is prepare up an estate plan for an 80-year-old couple that are changing the nappy of their 60-year-old son, and they worry about, when they're both dead, who is going to look after this vulnerable child who's profoundly in need of constant care. This is going to be a training course on vulnerable children. So when mum and dad die, who and how will those children be looked after, and how do you structure the protection of money in an Australian will? Welcome to Legal Consolidated. My name's Professor Brett Davies, a barrister of the High Court of Australia and the tax partner at Legal Consolidated. So there's lots of different types of wills that you can build. Mutual wills, dad to mum, mum to dad, or single wills, and they can either be three-generation testamentary trusts or they can be simple wills. But today we're going to build a mutual three-generation testamentary trust wills, mutual wills. Dad leaves everything to mum, mum leaves everything to dad. There's plenty of training advice on the introduction page, but we can also have a look at the sample document. All our legal documents have a full sample, so we always get a covering letter, and there's the will, and there's mum's will later on. There's also a checklist which will give you the questions that are going to be asked as you build this will on our law firm's website. Let us begin. The big green button, start building. Now, as with all our documents, you can pick up data from a previous document you've built, but in this instance, I will start the mutual wills, three-generation testamentary trust wills from scratch. So the first name, dad's name, dad's date of birth, dad's address, spouse's name, that's the wife's name. South Africa's probably not the best spot. Let's make it. Now, let's talk about the alias name. So if mum and dad, so let's say mum has assets in another name, like a maiden name, then she'll put that maiden name in, also known as. Now, the backup executors. And here we begin the questions. The best executors to have are the people that you're leaving everything to. And let's assume you've got 3 children. So for this example, I'm going to assume you have 3 children, one of which is vulnerable. Why is that child vulnerable? Perhaps they can't look after money, or they're spendthrifts, or they're alcoholics, or drug affected, or they have been mentally challenged with different problems throughout their life and they don't have the ability to look after themselves, much less money. In this instance, you need to make a difficult decision, because traditionally you would leave the job of being executor to all 3 children. Oh, Professor Davies, they'll fight. No, that's not. Don't worry about that. You have a misunderstanding of what the role of an executor is. The role of executor is one of servant. No, it's not a bossy boots position, it's one of servant. So the executors have to kowtower, they have to be polite to the beneficiaries. So let's make me the toffee-nosed professor in tax law. Make me the executor, because I'm very important. So what happens is you and your spouse die, and I'm reading the will. I'm sorry about your mum and dad dying. And one of the children says, oh, Professor Davies, I don't think the will, I'm going to challenge the will. All I could do was close the will back up and put it into the fireproof safe. I'm not the boss, I'm the executor. I have to act in the best interest of the beneficiaries. That's why it was better to have all 3 beneficiaries, all 3 children being the executors. So let's look at a situation where one of the children is an alcoholic. The other 2 children are fine, so you still may want to consider making the alcoholic child an executor. And we're going to change the age of executor for that child. This is the alcoholic child here. We're going to change the alcoholic child to get 1/3 of the assets. But we're going to dial up the age of majority. We're going to change the age of majority to not 18, not 21, not 25, but we're going to make it, in this instance, 99 years of age. So we have increased the age of majority for that one residuary beneficiary, one of your children. The other children, you keep the age of majority at 18 or 21 or whatever it suits you, but they're probably well above that age, they're probably in their 60s when you die anyway. But we are going to increase the age of majority to that vulnerable child to 99 years of age. Now, what does this mean? This means that 1/3 of your estate is now kept in a trust account under the control of who? Under the control of the executors. Oh, but Professor Davies, that means the alcoholic child is one of the 3 people in control of the money. Yes, and that may have advantages. That may have an advantage because that means that alcoholic child still has some interest and control of their 1/3. The other 2/3 have gone. They went years ago after you died to those 2 children. So the other 2 children have got their money and they've gone. The third amount of money is kept in trust in your estate for that alcoholic child, of which 3 people look after it. And you have to get permission from all 3 before you can pay any money out. So there's quite an extensive maintenance trust in your will, which allows the 3 executors to dish out as little or as much money as is appropriate for that vulnerable child. Now I'm going to repeat that again because that's a very interesting question, because people often want to rule from the grave. They want to rule from the grave. Never a good idea to rule from the grave. Oh, but I want them to have $50,000 a year to do this, or I want this. No, don't do that. Allow the executors to decide what's in the best interest of that vulnerable child from day to day. There could be Centrelink issues, or the child might need to fly to Sydney for a special treatment. We don't know. You cannot rule from the grave. If you have to narrow estate planning down to one word, it's flexibility. We don't know when you're going to die. We don't know what assets you have. You think you have those shares in BHP and you have that family home. You may not have any of that. And we don't know, thirdly, what the tax laws will be. So if you have to narrow estate planning down to one word, it's flexibility. And that's what that gives you. The 3 executives acting together can dish out as much income or capital as they see fit in order to protect that vulnerable child. That doesn't mean the cheque or the money goes directly to the vulnerable child. It might go to a hostel, or it might go to medical treatment, or to food and shelter. But that's the best interest test. At all times, the best interest of the vulnerable child. What's that? You don't want to make the alcoholic child one of the executors. I accept that. That's fine. In which case you only, in your will only have 2 executors, the other 2 children. And the other 2 children will maintain and look after the money on behalf of the alcoholic child. The reason I've picked alcoholism is because it's something very close to me. We've had a client, we acted for the mum and dad, they died, and there were 3 children, and one was an alcoholic, and they did dial up the age of majority in that instance to 70 years of age. The alcoholic child stopped being alcoholic. The alcoholic child stopped being an alcoholic and got married and had children and started to live a non-alcoholic, normal lifestyle that you and I would consider normal. The other 2 children said, look, if you can stay off the booze for the next 2 years, and we'll test you from time to time, we will release all the money that we hold in trust for you, we'll release it to you to use as you see fit, just like we've got the money. And that happened. And that happened quite a few years ago. And that child I met up with only recently and doing very well. And it shows the beautiful thing of flexibility in a will, that the other 2 children can release the money, 100% of the money, to that now non-alcoholic child. I wish all stories were as good as that. So we had the backup executors. So after mum and dad died, the backup executors would be child 1, child 2, and child 3. Sorry, in your case, the alcoholic child will not be an executor. And that's a fine decision to make. I'm not displeased with that decision. The age of majority. Now, in my will, I've made it 18. The other common date or age is 21 years of age, so I'll make it 21 years of age. What this means is that the age of majority for everyone is 21, except you've made it specifically 99 years of age for that alcoholic child or for that vulnerable child. But otherwise, it's going to be 21 for everyone else. You're saying, why does that matter? Because your children are now all over 21. Well, that's true, but remember, if a child dies, then what they would have got will go to their children. So let's say you've got a son called Robert. He's 50 years of age. He dies before you. You are leaving whatever Robert would have got. Let's say Robert was going to get 1/3 now to Robert's children. If Robert had have died in the same car crash as his children, and that bloodline of Robert is now gone, well, it just goes back to the remaining 2 children. So it's a self-correcting will. What's that? If Robert was to die, you would just change the will. Well, it's a bit cocky, isn't it? Because you've got dementia, perhaps, or you are in shock and grief. You don't want to change the will. You should draft a will that works today and also in 60 or 80 years' time. So always try and draft a will that never dates, or as much as possible never dates. Going to Robert's children is called a bloodline gifting will, and most wills in Australia are bloodline gifting wills. I now want to talk about specific gifts. You have a beautiful home, and your disabled child is used to living in that home, and you want to leave them a life estate. A life estate, and there's a hint here. Let's have a look. There we go. There's a life estate, or explanation of a life estate there. A life estate gives a person the right to possess the property unto the day of their death, and upon their death that right extinguishes and the remainder person. So in this instance it would be the vulnerable child has a right to live in your family home. When they die, that life estate extinguishes and the remainder persons take the property, which might be the vulnerable child's children, if he or she had them, or more likely the 2 remaining children that you've got. I do not like life estates. I don't like rights to reside. Let's have a look. Let's have a look at Google on life estates are bad. Lucky, live to air video, and there it is there. Legal Consolidated has got the #1 spot. So this is an article which our law firm's written on why life estates don't work. And I suggest if you do want to contemplate a life estate, have a good read and perhaps a good cry after you've read some of these terrible stories of life estates. I understand that that vulnerable child doesn't want to be moved, and understand that that home is where they know and been nurtured, but it's not necessarily in the best interest that that be in their name. There's Centrelink issues, there's land tax involved. Life estates are very adverse and tax unfriendly, and I would caution you not to, and talk to your accountant as well, and ring up our law firm as well, not to do a life estate. Well, I do want to benefit our children, this vulnerable child, more, because they need to be protected. I understand that. So instead of maybe leaving a third, 2 or 3 children, maybe leave 40% or 45% or 50% or 60% to that vulnerable child for the other 2 children to look after as the executors. Let's go back to this issue of backup executors. So after you and your spouse die, the 2 backup executors will be your 2 children. But they themselves will die. They could die well before the vulnerable child. The legal consolidated 3-generation testamentary trust wills are drafted so those executors over the years so 20 years after you've died, those executors can actually hand the role of trustee of that 1/3 for the vulnerable child. They can actually hand it over to someone else, maybe to one of their children or one of your great-grandchildren that have the ability to look after and help the vulnerable child while that vulnerable child's still living. So the residuary beneficiaries, in your case, after you and your spouse die, will be the 3 children. Disaster clause. What's that? Well, if you have a look to the right-hand side, you will see there's training videos on every single thing, lots of training videos, and also you can chat with us as well. So you can chat and speak to a lawyer. A disaster clause is only of use if you and your spouse, or if you're doing a single will, if you have children that travel with you or have family members that travel with you. Now, you and your wife and your 3 children their children are all under 18 and they travel wherever you go in the same car. The car could roll over and all 5 of you die. We need a disaster clause for that situation. However, if your children are all 20s, 30s, 40s and 50s and you never travel with all of them together, you don't need a disaster clause. But let's assume, just for the sake of argument, that all your children are young and they travel with you in the same car or the same aeroplane. In which case you would press yes to the disaster clause and you'd leave half of the combined assets of you and your spouse, half to your wife's side and half to the husband's side. So 50-50, if that's what you want to do. Most people do it, you don't have to do that. But so in which case, in this case, the husband's got 2 brothers, be 25% each, and the wife's got one brother, in which case she'll leave 50% of the combined wealth to that particular sibling. Disaster clauses are only needed if you have children or beneficiaries who are travelling with you or are young. Contemplation of marriage. 99% of people will say no to this. So if you have been if you're married to someone happily, and obviously you're doing mutual wills, you must be reasonably happy, you press no to both these questions. And that's what 90% of people are married and they're happily married. Well, they're going to stay together forever and they will press no to these questions. Let's look at the other 10%. So let's say you are in a de facto relationship with your partner for the last 40 years and you've got children and grandchildren, but you never got married. Maybe you're from the 60s. Now in the 60s, no one got married. It was all wild and free love, and no one needed a piece of paper to say they loved each other. Let's now say you're on a romantic holiday in Wagga, in the Botanic Gardens, very beautiful, and your partner magically pulls out a marriage celebrant and you get married. Your will is now revoked because in all states, Northern Territory, Tasmania, New South Wales, Western Australia, Victoria, and all states and territories right across Australia, marriage revokes a will, which means now you've got no will. So as you drive home from that romantic wedding, and if you die without a will. So in that situation, if you're in a de facto relationship, you should press yes and put in the name of the person that you'll marry. Now, obviously, you just can't put any. You have to put a real name in there. It has to be someone that that you're currently with. Now, someone who may get a divorce. That's really a bit strange. Well, again, you might be the same free-loving 60s parents, and your wife may have been married before, but never worried about getting a divorce, and no one cares. You've forgotten about it. In fact, you both have forgotten about that your wife was married, or your de facto wife was married many years ago and never got a divorce. You prepare a will. If divorce papers are now put on your wife and she does get a divorce, well, her will in most states is now nullified and void, in which case she should have pressed yes and typed the name of her old husband that she hasn't seen for 40 years. Very rare that you need a contemplation of marriage or contemplation of divorce clause. Now, guardians, if your vulnerable child is under 18, this is very important. If the vulnerable child's over 18, it doesn't have any force of law, but you can still put a guardianship clause in the will. Now, let's assume your child or your children are under 16, under 18. Someone will tell you that it's a waste of time putting a guardianship clause in a will. I'm going to tell you why they would have told you that. I'm going to explain why I think they're wrong. The reason that you would have been told at the dinner party, I've prepared up a will, a three-generational testament trust will at Legal Consolidated, and I've put a guardianship clause in the will. Ha, you wasted your time putting a guardianship clause, says the person at the dinner party. And your response is that what they're trying to say to you is that the guardianship clause doesn't necessarily override the state government. The state government controls who your children are with. So, for example, your children may well be at your home right now, but if you get arrested for drug abuse, or if you're not a fit and proper person, then your children, the state government, will take your children away from you today. Same in a will. You die and you appoint, let's say you appoint all 4 grandparents. So your mum and dad and your spouse's mum and dad, commonly, they're the 4 guardians. If one of them is not a fit person, then it's unlikely that the state government will approve that. But that's rare. It's very rare. You have a right to put a guardianship clause in a will or in a deed. Both are effective, so you don't have to necessarily put a guardianship clause in a will. I think it's a good idea to put it in a will because it's a very solemn document prepared by an Australian law firm, Legal Consolidated. So I think it's a good idea to do it. And I've never known the courts, and I've been practicing since 1988, I've never known the courts to override the wishes of a client that we prepared wills for. The other more interesting reason of guardianship clauses is that when you die, your will is lodged at the local probate office and becomes a public document, which means the Channel 7 news crew and the newspapers can get a copy of your will. And it publicly states that I want, upon my husband and my death, I want our infant children to be looked after by these 1, 2 or 4 people. That's a very important message, because what I've found in society is that even next door neighbours will come forward to protect your children. It's a wonderful thing. But in this instance, you've nominated someone in the will, and so is your spouse in their will. Guardianship clauses only come into effect once both of you are dead. Obviously, if the husband's dead and the wife's still living, well, then the wife continues to look after the children. That guardianship clause doesn't operate. But if the wife now dies, so the children are orphans, then the guardianship clause kicks in. I just think it's critically important that if your children are travelling with you and they're under 18, you should take the option of a guardianship clause. Now, your vulnerable child is a spendthrift. That's the problem. And that's why you've dialed up the age of majority for that particular child to, say, 50 or 60, not necessarily 99. 99, they're not going to get it. 60 or 70, they might get it. The people that can challenge your will are your parents, if you're looking after them, people you sleep with, like a husband and wife, your mistress, your gay partner, and you have all 3. Australia has legalised have legalised the ability to have more than one spouse. The people that can challenge your will are your children and stepchildren you're maintaining in most states, and also grandchildren, but generally only if the parent is dead. The vulnerable child can challenge the will. Well, how could that be the case? Well, the vulnerable child can challenge the will. I'm your favourite son, and you leave me 99% of everything you own. You and mum and dad, thanks, you leave me 99% of everything you own. And for my sister, you only leave 1%. So I get 99%, My sister only gets 1%. I could still challenge that final 1%. Sure, I wouldn't win, but I could still challenge. I've got the right to challenge the will for the final 1%. So you can see that whatever you do, you can't stop someone from challenging the will. And that vulnerable child might say, look, I want the 99-year clause brought down to my current age. I'm currently 45 years of age. I want it brought down to 45 years of age. I want to get access to my money immediately. They could challenge the will at the local Supreme Court on that basis. Or they could say, look, a third is not enough. My siblings are really rich and I'm poor and I'm vulnerable for whatever reason, and I want more money. I want more. I want to cut the cake a bit differently. And it may not be the vulnerable child, it might be the vulnerable child's friends, hanger-oners that are there trying to get hold of more money. Now, that instance, you can put a considered person clause in the will. So there it is there. It's called a considered person clause. And I'm going to put it in. So I'm going to name the vulnerable child and put them in the will. And I'll do the same also for my spouse. Same person. A considered person clause doesn't stop someone from challenging the will, but it makes it very difficult and expensive for someone to now challenge your will. So if you are in doubt, telephone us as you build the will, and we could talk about the considered person clause on who you need it for. I had a client who rang yesterday. She's worried about her husband's ex de facto challenging her will, and that can't happen. That's not possible in that particular jurisdiction, so we didn't need to put a considered person clause in for her will. But for his will, we did. So just telephone us. We can give you free legal advice as you build your documents. So let's now have a look at the summary. Now, the summary will set out all the answers to your questions. And I can see here, there's my spouse, Colin Smith, in Campsie. I can see that, no, I need to fix up the spelling of that residuary beneficiary. So I'll go here and I will take out the name. And what happened there? That's interesting. The lock and build button disappeared. Now, our law firm is responsible for these two wills. These three-generation testamentary trust mutual wills are the responsibility of legal consolidated barristers and solicitors, and therefore we carry the logic flow responsibility. So we will only allow you to build this document if the logic flow is correct. And now the lock and build's there. And I can go back to summary. I can now keep checking it. And that looks all correct. The references, I'm not going to have my corporate logo put on. Accountants, financial advisors and lawyers will often put their logos on the wills. It's not just a mum and dad in this example. I could have the will explained to me, and I could also have the documents bound and posted. I don't need any of that for the time being. I'm now going to press lock and build. Put in my credit card details. And my credit card details have been accepted, and the document within about 12 to 20 seconds is now been emailed to me, and I can also access it. And I can come back today or in 20 years' time and access any document I've built on the Legal Consolidated's website. So there's the mutual tax effective wills we've just built. And let's have a look at them. It's come through as a locked PDF. Hang on, a locked PDF means I can't change it. Of course you can't change it. Our law firm's prepared this document for you. You get unlimited free updates of the document. So if you ever need to update it, just email us and we'll give you a voucher to update it. You can update your powers of attorneys and your wills for free, as often as you want, for the rest of your life. So if you need to change the will next year or in 20 years' time, just email us and we'll help you change it at no charge. And there it is. The three-generation testamentary trust mutual wills. It's on law firm letterhead confirming, thank you for instructing us to prepare your attached three-generation testamentary trust wills. We alone are responsible for these documents. Our law firm is responsible. So that's how to print it. Oh, 32% tax on super. What's all this about? Well, we're a tax law firm. Let me tell you something. There is major tax issues at death. And one of them is that your superannuation, you know, that superannuation we're contributing to that's meant to be a tax-free environment, it might be tax-free for you, but when you die, there's up to 32% tax payable immediately upon your death on your super. Oh, I've never heard that before, Professor Davis. Who will ring up your financial advisor, talk to your accountant about it. There are three components to your super: concessional, non-concessional, all the rest. On your concessional component, it's 15% plus Medicare tax going to adult children. And for everything else, other than concessional or non-concessional, the tax is 30% plus Medicare. It's up to 32% tax super. We've put a superannuation testamentary trust in your will to try and wash that out. And because you've got a vulnerable child, it's highly likely that tax, at 32% tax, or that 15 plus Medicare percent tax will be reduced to zero. But you've got to follow the rules to do that. Nothing to do with your will, because superannuation does not form part of your will automatically, but you can make it do that. And this article shows you how to talk to your super fund or amend yourself in your super fund to allow that. Super's a really big issue. Really big issue for tax. Joint tenancy property. If you own your family home, I'm not that fussed whether it be held as joint tenants or tenants in common, but if you've got commercial property, you and your spouse have commercial property, it's better to own it as tenants in common because it can become, will now become pregnant with capital gains tax. So even if it's a pre-1985, if you're lucky to have a pre-85 asset, once you die, that half will now become subject to capital gains tax regime. So every bit of property eventually becomes subject to capital gains tax regime other than your family home, and you probably should sever the joint tenancy and make it tenants in common. It's in the letter. Just telephone us and we'll help you for free, guide you through what you need to do there. Assets. Now, our wills are drafted to deal with all assets in all other jurisdictions. And if you're unsure, just telephone us and we will help guide you. So if you've got assets in California or in Italy or in Great Britain, then we will guide you. In fact, all those jurisdictions our wills operate. But let's say a more exotic country, just ring up and we'll guide you on whether you need to do a second will in that jurisdiction or whether this will operate for it. No charge. It's all part of the service. Family trusts. Oh, a lot of, in fact, virtually every small business owner was going to operate through a family trust. A family trust assets do not form part of your estate. The appointer in a family trust deals with family trust assets. So if you've got family trust assets, the will does not get involved in that. Telephone us, we'll give you a hand with that. Who can challenge the will? Going through those rules. You must always get a doctor's certificate saying you're of sound mind. I'm giving you the wording. Although I must say, I don't think any lawyers actually followed the wording, but it gives you the gist of what we'd like the doctor to write. Effective divorce. It's interesting, the will contains a divorce protection trust so that if one of your children get divorced, the assets are protected from the divorce proceedings. And that not only helps the vulnerable child, but all your children, also your grandchildren and great-grandchildren, because the three-generational testimony trust operates for up to 80 years from the date of your death, and in South Australia it acts indefinitely. Special disability trusts. We have put in your will a special disability trust. It's in all our three-generation testimony trusts, and it helps for Centrelink benefits. So at the moment, your vulnerable child might have died, and it's now the next generation, the grandchildren, that are reaping the benefits, and one of those children suffers an event which makes them disabled, and therefore this special disability trust can come in play 40 years after your death in order to protect the wealth from Centrelink, being means tested for Centrelink. So that's the covering letter, and here's the will. So this is the husband's will. Shouldn't really use those sexual expressions of husband. This is your spouse's will. The three-generation testimony trust revokes previous wills. There's your executors. The age of majority was 21. I could have made it 18. And then let's have a look. So everything goes to each other. So in this instance, if the wife, that's Mary, so this gentleman's married to Mary, if Mary outlives her husband for 28 days, then she gets everything in the will. It's a classic mutual will. Why 28 days? Well, under Australian law, if you and your spouse die and no one can work out who died first, so in a car accident or an aeroplane crash, you don't know who died first, the older in time is deemed to die first. So if the husband is older than Mary, the husband's deemed to die first, and everything goes to Mary. But if Mary died 1 second later, you've got all the issues of tax. So every time you move wealth, you've got stamp duty, capital gains tax, the superannuation taxes, income tax. In order to override that, 28-day clause has been put in this will so that Mary's got to outlive her husband by 28 days before she can inherit. It's a tax-driven and administratively reduces costs. Now, the children of the prime beneficiaries, this is what we spoke about, that if someone dies, if a child dies, it just goes to their children. Now we'll look at clause 8, which deals with maintenance trusts. If, and this is really important section for vulnerable children, let's say they haven't obtained the age of the majority, and for the vulnerable child, we made it 99 years of age in this will, then the money can still be used, the wealth can still be used for maintenance, education, advancement, support and benefit of that vulnerable child. That is as wide as we can legally make. That's the most discretion we can give to the two executors in order to help that particular vulnerable child. That's not ruling from the grave. That is giving the people living, your two executors, the right to give thought to what's in the vulnerable child's best interest. And that's the most powerful protection you can give. What about if later one of the children suffers mental incapacity? Well, again, what happens, because they can't sign a receipt, the money just gets stuck in the will. But in this instance, the money can still be applied for their benefit, education, advancement. Again, very widely drafted. There's also a bankruptcy trust. So a lot of vulnerable children that are spendthrifts may well suffer bankruptcy. They will lose all their money, but they won't lose any of the money you're giving them under this will, because there's a bankruptcy trust in the will. And the fourth mandatory trust in the will is the divorce proceedings trust. Now, this is a divorce protection trust. So if any of your children or grandchildren or great-grandchildren die, it works for 3 generations, then the assets are put back into the trust. And because the child can't touch the money, it's highly likely the family court can't touch the money. And at this point, we haven't lost one yet. But the family court's very powerful, so it may not always operate, but it's the best you can do, divorce protection trust. Clause 9 deals with all the powers that are available to protect the vulnerable child. So income can be accumulated. It doesn't necessarily have to be paid out. You can move the assets around. So, for example, you may be able to buy that family home or pick up that family home from your estate, from the remaining 2 other siblings. This can be done because it's a 3-generation testamentary trust. You can often manipulate the assets between the 3 children. So let's say there's $6 million in your estate and the family home's worth 2. The vulnerable child could get the property for $2 million, and the other $2 million worth of shares and cash go to those other beneficiaries, those other 2 children, potentially for no stamp duty or capital gains tax. A very powerful benefit of a 3-generation testamentary trust. So you can see these powers are all here. Streaming provisions, your accountant will want to see that, so you can actually have capital gains and capital losses be dealt with in a very friendly tax manner. There is new rules in most jurisdictions, most states, that if one of your children happens to be living in England or overseas, they could be dealt with or treated as a foreigner under the trusts and therefore suffer higher land tax and higher stamp duty. This clause 10 seeks to nullify that. There's your considered person clause. So you can see it's not it's reasonably friendly. It's not a mean thing to say. Clause 12, in this particular will, the numbers are different. It deals with the superannuation testamentary trust in order to wash out the 32% or 15% on your super. There's a signing clause. So you sign it at the bottom of each page, and the 2 witnesses sign in the same blue pen. And there's the wife's will, or the spouse's will, which is a mirror image. The mutual wills, a mirror image of each other. So you can see she's doing exactly the same thing. So that is the information which our law firm wanted to give you regarding vulnerable children. But your circumstances are your own, and you're welcome to telephone us and we can help you build this document on our website for free. Telephone us, we'll be happy to talk to you regarding preparing a will for you and your family to protect the vulnerable child.